Good evening. Happy Wednesday. This is document 100 in Decastro versus Abrams et al. This is plaintiff's opposition to defendant's motions to dismiss. A response is not the right word to use here. Now, this is not fatal, but this just clearly illustrates that Chili doesn't know what he's talking about. As far as motions are concerned, there is the motion. There's the notice of motion and motion. That's what the moving party files. Then the opposing party files an opposition. They're opposing it. It's an opposition. And then the moving party may file a reply. It's a reply to the opposition. That's motion stuff. And then there's rarely there's a SIR reply that the defendant gets to file a SIR, the non-moving party gets to file a SIR reply. Rarely. You have to ask leave of the court to do that. Anyway, that's for motions. A response is typically something you file to a petition. So a petitioner will file a petition, and then the respondent will file a response to the petition. Typically, maybe some local rules or local customs will change things. Like in California, in family law, a motion is called a request for order. And the opposition to a request for order is called a responsive declaration to request for order. But typically a response is something that you file to a petition. It's to oppose a petition. And then, of course, a plaintiff files a complaint and a defendant files an answer to the complaint. So response is not an appropriate thing to put there. Again, not fatal, but it just shows that he doesn't understand the words that he's using. To the Honorable Judge of said court comes now Plaintiff Jose Maria Decastro, an individual appearing pro se in the above entitled case, hereby file this, his response in opposition to defendant's motion to dismiss under Rule 12b, and would show the court as follows. Now, all of his gobbledygook could have simply been phrased as Plaintiff Jose Maria Decastro opposes defendant's motion to dismiss under 12b-6 as follows. But what do I know? Case activity. Plaintiff filed his original complaint on 9/2/22, which was amended on 11/16/22. There's a lot of little errors, like formatting errors in here, like the extra slash. There's that weird thing, whatever this weird thing is. It looks like a closed parens that's maybe underlined. I don't know. In which he seeks restitution for damages and other relief for injury he has suffered by actions of these defendants, including, in part, defamation and copyright infringement. Now, restitution is a specific form of recovery in civil law. Defendants in criminal law may be forced to make restitution, but in civil law, it is part of a contract recovery. It's similar to unjust enrichment. It's basically where you restore, where the party who's been unjustly enriched restores the defendant to, or not the aggrieved party to that aggrieved party's original position. Say, for example, you have a contract with Billy Bob to put a cement driveway in. So you buy 10 tons of cement. And then Billy Bob says, no, I don't want you to cement my driveway. Well, then you sue Billy Bob for restitution because he didn't get anything. Billy Bob didn't get anything, so you can't sue him for unjust enrichment. It's breach of contract, but the remedy you're seeking is restitution. You want to be repaid. You don't want to be out that money that you paid for the 10 tons of concrete, right? That's restitution. It's for contract actions. It's a contract remedy. Unjust enrichment would be like if you put the 10 tons of concrete in, if you poured the driveway for Billy Bob, now You can, for breach of contract, you might sue for restitution for the cost of the concrete. You might sue for unjust enrichment for the amount of value that you added to Billy Bob's property. You might sue for the actual amount of the contract, the amount of the money you were supposed to get. Remedies is a whole class in law school unto itself. But needless to say, restitution is not what he's seeking here. It's not what he's seeking here. He's seeking damages. He's not seeking restitution. Each of the defendants filed a motion to dismiss plaintiff's action, ECF numbers 94, 95, and 96, to which plaintiff hereby files his response in opposition. Again, it's just his opposition. Argument and memorandum. This is where we're going to see Chile take the law and apply it to the facts and say why the court should deny the motions to dismiss. And why are we numbering our paragraphs here? Why are we numbering our paragraphs? That's weird. Normally you number your paragraphs in a complaint. You don't normally number your paragraphs in an opposition to a motion. So that's weird. To state a claim for copyright infringements, plaintiffs may only allege one, that they own valid copyrights, and two, that defendant violated one or more of the exclusive rights set forth in 17 U.S.C. section 106. For example, by copying or distributing plaintiff's copyrighted works. See this Supreme Court case. Moreover, Rule 8A requires, in pertinent part, that plaintiff's complaint include 1. A short and plain statement of the grounds upon which the court's jurisdiction depends, 2. A short and plain statement of the claim showing that the pleader is entitled to relief, and 3. A demand for judgment for the relief the pleader seeks. Now, this is there's two, so in order to survive, in order to be a sufficient complaint for purposes of actually putting the defendant on notice of what you're suing them for and the amount of money you're suing them for, it has to contain a short and plain statement. I mean, it's very, very simple. It's very simple. It's notice pleading. You have to put the defendant on notice in federal court, on notice of what they're being sued for and how much potentially they're on the hook for if you win. But that's just the basics that you need to file the complaint, so that if, for example, the defendant never opposes it and you go for a default judgment, then you can actually get a default judgment. So that's like the very basic. If the defendant doesn't oppose it, you could get a default judgment as long as you have a complaint that says what essentially you're suing the defendant for and how much you're suing him for, and serve it on him. Obviously, you have to serve it on the defendant. But to survive a 12b-6, you have to allege facts sufficient to show that if the facts that you allege are true, then you could actually prevail at trial. That if nothing else happens, if the defense doesn't put any facts forward that oppose your facts, that if all your facts are true, you win. Which is a different standard entirely than just having enough of a complaint to survive if it goes to default judgment. I've said that a couple times before in previous videos. I don't know if that makes sense to people. Like, for example, Blue Bacon won, apparently, against Chile because he managed to get Chile served, and Chile didn't oppose his petition. And so it's pretty simple. All you have to do is allege enough in your petition that a court could find in your favor and grant you the relief that you seek. That's it. But if it was opposed, if Chile showed up, if the defendants show up and put up a fight, then you need more. then you need more, which is why you should always start with a well-pleaded complaint. You should allege those facts, because you got to assume that the defendants are going to show up, and they're going to show up to fight, and they're going to try to get your complaint dismissed for failure to state a claim. Defendant suggests that the complaint fails to plead specific works and ownership and fails to properly allege infringement. The face of the complaint shows that those arguments are without merit. So this is where he's going to show the specific language in the complaint where it says which specific works are owned specifically by him and were used by defendants, specifically by specific defendants, in a manner that infringed his copyright. First, only one of the defendants, the defendant possessive, even questions my ownership in their motions for dismissal under 12b-6. They don't have to. They don't have to. And why did you have first in the same paragraph, number one? Because the face first, I pled these specific works. Second, I stated I own them. Third, I alleged properly in the complaint that they infringed on those rights. But no, he says only one of the defendants even questions my ownership. That's not the point. The point is, what does the complaint say? Does the complaint say, I own these works? That's what the complaint has to say. Defendants in their prior motions admit to and list specific recording that infringe on plaintiff's existing copyrights. Well, it's not what the defendants do. This 12b-6 motion is about what the complaint says. You're looking at the complaint. The complaint has to state a claim upon which relief can be granted. You're barking up the wrong tree. Additionally, potential confusion as to which recordings of the defendants are infringing can be further clarified through the discovery process. Again, you got to get to the discovery process. You have to survive to get to the discovery process. You have to state the claim in your complaint to get to the discovery process. Dismissing the plaintiff's complaint would seem premature at this stage of the litigation. That is specifically what the stage of the litigation is for. Specifically, they're testing, the only thing they're testing is the sufficiency of your complaint. That's what the stage of the litigation is for. At this stage, plaintiff need only allege ownership of the copyrighted recordings, which he has done. Citation needed. Because remember, up here, he said, defendants allege the complaint fails to plead specific works and ownership and fails to properly allege infringement. And now he's saying the plaintiff only needs to allege ownership of the copyrighted recordings, which he's done. I don't believe so. He has to tell them, the complaint has to say to the defendant what they've done wrong. You can't just file a lawsuit and say, I own these documents, or I own these recordings. Because that doesn't tell the defendants what you're suing them for. Specifically, like, you have to say, like, you used this work of mine in this work of yours, and it's my copyrighted stuff. And so you infringed on my copyright. Any question as to the plaintiff's ability to prove the well-pled allegations of the complaint is not relevant in a context of a 12b-6 motion. Well, they're not saying that you can't prove it. They're saying you haven't pled it. Any contention that plaintiffs... Why does he refer to himself in plural all the time? Any contention that plaintiffs should be required to prove allegations of ownership at this juncture is simply without basis. These two sentences appear to repeat themselves. Such an obligation would put an increased burden on the court clerks without benefiting the defendants. What? How would it put a burden on the court clerks? Is Shelley thinking he'd have to file some sort of proof? That's really weird. God, the guy has no idea what he's doing. The fact that the defendants have not requested a more definite statement, but rather asks that this court decide fair use, makes it clear the complaint was sufficient to give notice. No, it doesn't. It doesn't. The complaint has to say that you own this recording and that they used this recording in violation of your copyright. And you have to like say where they used it too. You can't make them guess. This isn't a game of hide the ball. The fair use determination is not obviously in favor of the defendants and is obviously against them. Clearly. This is just such a pet peeve. Like show me. Don't tell me, show me. The defendants are in the same market and have admitted it in their videos and have infringed on works of the plaintiff that are unpublished where courts have found that fair use is not a defense regardless of their purpose. Citation needed. 9. Plaintiff's complaint complies with Rule 8. Period? I don't know. Maybe he meant to say more and just got really stoned and forgot about it. I don't know. He starts off with plaintiff's complaint complies with Rule 8, and he ends with plaintiff's complaint complies with Rule 8. Okay. RICO, B, RICO. Number 10, RICO is only used as a jurisdiction method for defendant Abrams to be in the same action, but is pled sufficiently in the mass copyright infringement for financial gain occurring by defendants. What the fuck does that even mean? You don't need to plead RICO to sue Abrams and Peter at the same time. You could have one lawsuit, multiple defendants. But is pled sufficiently. I'm not going to waste my time on it. I don't know what that sentence means. I don't know what he's trying to say. It doesn't make any sense to me. RICO, he doesn't have a RICO cause of action, and he doesn't need to plead RICO to get jurisdiction, and he doesn't actually effectively plead RICO at all. Not even close. So I don't know what he's trying to say there. YouTube and YouTube terms of service. Defendant Abrams raises defenses related to YouTube terms of service. Abrams has no way to know which agreements that plaintiff has entered into with YouTube. Abrams has no way to know which agreements that plaintiff has entered into with YouTube. I'm not entirely sure that YouTube terms of service are unique for each individual user. But that would be interesting. It is interesting. I mean, I'm not saying that, well, Chili's retarded. Let's just, I'm not going to mince words on it. But are the YouTube terms of service pled sufficiently in the complaint? They're all YouTube videos. So is the YouTube terms of service, are the YouTube terms of service, I don't know which it is, I don't really care. Are they tied tightly enough to the pleadings in the complaint for the court to assume them or to take them into consideration? That's a good question. Chile isn't making that argument, but that's a good question. I mean, a real lawyer would have. I was actually thinking about that previously. Is will the court actually take the YouTube terms of service into consideration, or will the court say those are extraneous to the complaint? You could make an argument either way. Chile doesn't, but you could. The small portion of a specific version of a generic YouTube term of service that Abrams allegedly pulled from YouTube's website does not apply here, nor has Abrams interpreted the passage correctly, nor is it even possible to interpret the passage with the entirety of the document, as it's not cited in a way to know what the remainder of the document might have been. This right here is Chile's patented nope defense. If he just says no, then he wins. Certainly, clearly, obviously, patently, all visitors to the YouTube website do not give up all of their creative content into the public domain. This is irrelevant to a 12B motion to dismiss for failure to state a claim. Well, I mean, is that certain? Is it certain that every person who posts their content on YouTube gives up all of their creative content into the public domain? What if they give up some of their creative content into the public domain? Now, I think that Abrams is certainly interpreting those YouTube terms of service creatively, because I believe what they're talking about, what YouTube is talking about, is when like a website embeds a YouTube video into their website, and it still plays on YouTube, and YouTube still gets the ad revenue for whatever ad plays on it, etc. But it's on somebody else's website. They're not violating copyright because it's playing a YouTube video off of YouTube. Does that make sense? You know, YouTube's still getting, it's still a YouTube video, even though it appears on someone else's webpage. I think that's really what YouTube is going for, but whatever. Conclusion. Well, that was quick. I don't think, did he cite a single case in here anywhere? A single case. We got a, oh yeah, we do. We got, well, let's check it out. Let's check this case out. He doesn't actually cite a page, but let's check it out. Make that a little bit smaller. I don't want this. All right. What was he talking about? He was talking about to state a claim for copyright infringement. May only or must only. Or in the case, go to the case. Valid copyrights. Here we go. To establish infringement, two elements must be proven. To establish infringement. To establish infringement. Not to plead it. To establish infringement, they must prove ownership of valid copyright and two, copyright or copying of constituent elements of work that are original. I believe that is what Chile was trying to get, but he messed it up. Boy, so the one citation he makes is a bad citation. So it appears from a quick perusal that this is about copywriting fax, copywriting the phone book. Telephone server, subject to state regulations, has to issue updated telephone directory, white and yellow pages, FICE publications in a wide area telephone directory, much larger geographical range. So FICE used rural's white pages. So it's not really very on point, is it? So anyway, the one case that he cited was inapposite, so good job, Chili. The plaintiff's complaint pleads a plausible case that allows the court to draw the reasonable inference that defendants are liable for the misconduct alleged. Oh, this is dookie. The plausibility to the claim as a whole and not to each individual allegation. The plausibility is to the claim as a whole and not to each individual allegation, and the courts have determined that each fair use determination requires a trial of the facts. No, it doesn't. You don't go to trial on fair use. Fair use is a matter of law. The court will usually determine whether or not there's fair use. I don't believe that's a trial issue. I believe that's a court issue. But on a 12b6 motion, the court has to assume each fact as pled in the complaint is true, unless it's something that obviously isn't true. Like if he says that Austin, Texas is 6 miles away from Dallas, Texas, well, the court doesn't have to accept that as true because the court can take judicial notice of a fucking map. However, if everything else, unless it clearly can't be true, unless there's no way that it could possibly be true, the court has to accept the allegations as true. And so it doesn't matter if it's plausible. What matters is, did you say, A, I own this work, B, this work is copyrighted, C, defendant used my work in violation of my copyright, and D, this is where they did it. Unless you could really show those things, you're not hitting on all cylinders. You're not really going to have a good time in a 12b6 motion. I don't think Chili's met his burden here. Plaintiff requests the court deny defendant's motions for dismissal of its claims and or grant it leave to amend the complaint where it believes the complaint fails in the interest of justice and to prevent further expense by all parties. I expect the court is going to allow him to amend his complaint. And then we have document 101, which is motion for leave to file a second supplement to first amended complaint. Now, I haven't read this yet, but I'm hoping that he's using this correctly this time, and so the way a supplement works is if there is something that happens after you file the complaint, if they add on a new cause of action after you file the complaint, you could supplement the complaint to plead in the recent causes of action, the causes of action that happened after you filed the complaint. You amend the complaint to include causes of action that happened before you filed the complaint, but that you failed to include in the complaint, or to fix pleading issues. You supplement the complaint to add causes of action that happened after you filed the complaint. Now, another weird thing here is that the court called it a second amended complaint. They didn't call it a supplement to the first amended complaint. So this leaves lots of question marks in my head about what the court's going to do. Pursuant to Federal Rule of Civil Procedure 15D, Chile respectfully moves this honorable court for leave to file plaintiff's second supplemental complaint to add Peter's latest copyright infringement of a previously unpublished video as mentioned in ECF number 97. Courts may permit supplemental pleading, setting out any transaction, occurrence, or event that happened after the date of the pleading to be supplemented. Yeah. So this might be actually the court. The court might end up considering this a first supplement to the second amended complaint. Just so you know. The First Circuit has recognized that courts customarily have treated requests to supplement under Rule 15d liberally. I would expect that to be true. This liberality is reminiscent of the way in which courts have treated requests to amend under Rule 15a's leave freely given standard. Also see this Ninth Circuit case. Okay, I don't know why you're quoting Ninth Circuit when you have a perfectly good First Circuit case to quote, but fine. The Ninth Circuit case apparently says that Rule 15d is intended to give district courts broad discretion in allowing supplemental pleadings and as a tool of judicial economy and convenience, and its use is therefore favored. Yeah, I suspect that if his supplement is at all reasonable, then the court will grant it. Here, plaintiff filed his first amended complaint on November 16, 2022, document number 60 of the record, after which Peter infringed on another of plaintiff's copyrighted videos as mentioned in ECF number 97. ECF number 97. Oh, come on, God damn it. What do we got here? I have a lot of internet connection issues out here, especially with all the storm going on, so I apologize. Oh, in his response to the motion for contempt, congratulations. Speaking of which, we'll have that loading. Has anything happened in that case? Still no. All right. After which, Peter infringed on another of plaintiff's copyrighted videos as mentioned in ECF number 97. Plaintiff could not have known that Peter would have behaved in this tortious. It's now a tort. It's now a tort. It's no longer copyright infringement. It's a tort. A tort is a completely separate thing from a copyright infringement. A tort implies a duty, a breach of duty, and harm. Those are like the basic elements. Harm has to be legally and proximately caused by the breach. Copyright infringement is not a tort. Last time I checked, but what do I know? What do I know? No factors exist that would support denial of plaintiff's motion. So this F3rd, that's not a... Oh, is this... It's this one. C US X Roll Gad Boys V for AmeriCorp. Supra 809 F3rd at 7. All right, let's see what we got here. Just for shits and grins. At 7. For one thing, is it implicit that a motion to supplement may be denied where the referenced events occurred before the filing of the original complaint. For another thing, leave to supplement may be withheld if it would unduly delay resolution of the case. In the last analysis, must weigh the totality of the circumstances just as it would under 15A. Idiosyncratic factors, say the utility or the futility of supplementation, prejudice to opposing party, and unreasonable delay in attempting to supplement, may suffice to ground a denial of the Rule 15D motion. Everything depends on context. I don't believe that is an exhaustive list. It doesn't say that that's the entirety of the list. So yeah, he does say it's just some factors. Plaintiffs have not unreasonable. Why is it plaintiffs plural? You are only one dude, bro, playboy. Plaintiff has not unreasonably delayed in attempting to supplement. This motion comes less than 30 days after the facts arose, with 2 holidays during that time. The supplemental pleading will not unduly prejudice the defendant and will help prevent her having to participate in another related suit. And Peter decided to make further infringements during this action. So the court may permit the supplementation even though the original pleading is defective and say, all right, that's okay. It was just a thought that went through my head. Supplemental pleading will not unduly prejudice blah, blah, blah. Plaintiff's supplemental claim is not futile. Plaintiff's possessive. Plaintiffs plural possessive have pleaded allegations which, if taken as true, as they must be at this stage, state a claim for which the court can grant relief. An amendment is not deemed futile as long as a proposed amended complaint sets forth a general scenario which, if proven, would entitle the plaintiff to relief against the defendant on some cognizable theory. So this is talking about amendments, not supplements. This is talking about an amended complaint, not a supplemental complaint. So, close, but no cigar. But, yeah, so the court can permit the supplementation even if the original pleading is defective. Since supplementation will aid in the speedy and effective relief of plaintiff's related claims, plaintiff respectfully requests the court grant plaintiff's motion for leave to file a second supplemental complaint. He didn't attach it. 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 He was supposed to have actually attached a copy of the supplemental complaint so the court can see it, and then he would have to, that would be what he would have to file, would be the supplemental complaint that he attached to his motion. But he didn't attach the supplemental complaint to his motion. So I don't even know what the court's going to do there. The court may instruct him to file as like 101 subpart 1 the proposed supplement, so because the court needs to have a chance to review it before the court will decide whether or not to allow him to file it. And that's weird, this one isn't numbered like the other one was. Remember how this one was like all that? I wonder if, so you have 2316, year, month, day. And then this one is January 11th, 2022. So it's year, or I'm sorry, it's month, day, and then the wrong year. And this one is motion to supplement PNAC, docx. And this one is not. What are you? It's a Word document. Authors, new user. This one doesn't have an author. I think two different people wrote these. I mean, they're both garbage. They're both absolutely garbage. But the difference is in the naming conventions, and one has a author and the other one doesn't. Chili spent, it looks like, about an hour and a half amending it from whenever somebody wrote it. And then this one, Chili spent 10 minutes amending it after somebody wrote it. Anyway, I've faffed about enough. So, yeah, I mean, my gut instinct is always that the court is going to allow a pro se litigant to amend, especially if it's something as simple as, like, if the court doesn't know whether or not there was a copyright infringement. The court doesn't know that yet. The court knows there's a bunch of videos out there, and that's all the court knows. So I assume that the court will allow Chili leave to amend his complaint. Anyway, thanks for watching. Have a great day.